Good afternoon, everybody. Welcome to Truly Sinister. My name is Wendy, and today we are going to discuss the Alexander brothers from Miami. They are on trial for sex trafficking and other crimes. Um, these are three brothers who were raised in with a silver spoon in their mouth. They can do no wrong. Since high school, they have been um, raping and abusing women, girls that in high school they were young girls, but now women, for over a decade. And they were finally caught and arrested, and they have been held in jail since their arrest in 2024. And they are on trial. Their trial is not being streamed or aired on any news channels or anything because it is a federal trial, and federal courts don't allow media cameras in their courtrooms. So we're having to follow up on certain channels and certain people who are watching the trial in person and writing summaries of the day's events in the court. And so that's what we're having to rely on to report to you how the trial is going. These three brothers, there are two twins, and then there's an older brother, and they are disgusting human beings, to be honest with you. They think that their wealth can get them out of any sticky situation that they find themselves in, and they have been behaving as such since their arrest. In fact, I have a video that talks in my playlist that talks about how one of the brothers appealed to the judge asking her to let him out on bail because his wife was having a baby. And of course she denied it, and rightfully so. I mean, nobody else gets out of jail for personal things like that. Why should he? But he felt like he was entitled, and he was certainly surprised that it was denied. But it's like that kind of shit is exactly what these brothers, excuse me, are known for. They think that they're above the law and that their money's going to get them out of whatever predicament they find themselves in, and apparently it has all their lives until now, and now they're facing multiple charges and multiple years in prison for their actions, and it's about time. And I'm sure these victims feel like it's about time for sure. The one victim who initiated the investigation against the Alexander brothers, she's from Australia. She was, a week before the trial was set to begin, she was found dead in her home under suspicious circumstances, and they have not yet publicized her cause of death or anything else about it. They just know that it's suspicious. So I don't know that if their reach can reach that far. I mean, if you have money, I guess you can send somebody anywhere to do anything for you, but hopefully that is not the case, because then they will find themselves in a lot deeper shit than what they're in right now. So that being said, I have some court documents that I've come across, and I will continue to search for more as the trial goes on, that I want to go through today, plus an article about it that actually speaks about the parents for once, because I've always wondered what their parents think, and it's just as I suspected. Their parents think they can do no wrong and are siding with their sons in this, and their sons are just angels, and they can't believe that they're being basically held accountable for their actions is what I'm getting from it, but whatever. So we'll start with that. I hope everybody's having a good week so far. It's really stormy. It rained continuously, like poured continuously for the last 2 days here in California. And it's cold, so it sucks. This weather sucks, and it makes me depressed, and it makes me not want to get out of bed. Plus, I woke up with a terrible migraine yesterday, which didn't help matters any, so I was in bed most of the day. I haven't had a migraine like that in a long time. I used to get them like once a week growing up, but I haven't had one like that in a long time. Even just touching my head, it hurt, and it sucked. And my husband, of course, is miserable. We think he's allergic to whatever they're wrapping his arm in, and his arm is red and swollen and oozing, so we don't know if it's infected. He has to go back. We went to the doctor yesterday and to get a cast, and of course they didn't cast it for that reason, so we have to go back tomorrow, and hopefully they will cast it tomorrow. But yeah, it's coming from all sides, it seems like, and it's pretty frustrating. Just when you think your shit can't go wrong, more shit piles on. It's like, when's enough? Okay, so crime hunter. Did uber wealthy Alexander brothers play 6 sex games? The sex-obsessed siblings allegedly used the same playbook over a dozen years and never took no for an answer. You know, and they were recently, in my last video about them, they were found to be in the latest dump of the Epstein files. Yeah. So I guess you know you've made it as a sex predator when you've made it into the Epstein files, right? I mean, is that something that they strive for, or I mean, you know. Anyway, so let's take a look. This was published on Saturday, February 14th. Okay, to hear prosecutors tell it, the 3 Alexander brothers made getting laid a twisted, vile, stomach-churning pursuit. No clumsy frat boys were they, according to Assistant U.S. Attorney Madison Smizer. The sex-obsessed siblings allegedly used the same playbook over a dozen years and never took no for an answer. They didn't have to. Cops claim most of their alleged victims were catatonic after being roofied, and the brothers would then take turns graping the women and girls. Just one second, I got a cotton mouth like you couldn't believe. The other 2 would allegedly watch. This apparently went back to high school. And now the 3 brothers are on trial for sex trafficking, which appears to have become the sport du jour among the rich and famous. Epstein, Maxwell, Nygaard, P. Diddy, the gang is all here. Oren, 38, and Tal Alexander, 39, were luxury real estate brokers who specialized in high-end property in Los Angeles. Their brother, Alon, Oren's twin, graduated from New York Law School and runs the wealthy family's private security firm. Your noon hour look at what's happening in Toronto and beyond. What? I don't know what that was about, but anyway. We know who our boys are. Like the siblings, their parents are not shamefaced about the boys' alleged grapo antics. They said in a statement, quote, "We know who our boys are and we believe in their innocence," end quote. According to the feds, the Alexander boys allegedly became the Robb Report grapists while they were still in high school in Miami. Quote, several of these victims were given alcohol by one of the defendants or other individuals, end quote, prosecutors alleged, adding that victims reported, quote unquote, hearing that individuals involved, including Tal Alexander, talked about the assaults at school, boasting about running a train on their victims and saying that they wanted to do it again. Orrin Alexander allegedly even boasted in his high school yearbook that his most memorable moment was, quote unquote, riding my first choo-choo train. Prosecutors said the brothers allegedly used whatever means necessary. They were, after all, entitled to their entitlements. Luxury hotel suites, flights, drugs, and booze were allegedly the tools in their chest. When that failed, they allegedly used the old standby of violence. Tal, Orrin, and Alon Alexander allegedly, quote unquote, masqueraded as party boys when really they were predators from 2008 to 2021. But their lawyers said the brothers were merely successful, ambitious, and maybe sometimes arrogant. Sex was their hobby, and they pursued it in nightclubs, bars, restaurants, and online during the peak era of the hookup culture, end quote. The quest for sex dominated the brothers' every waking moment. Quote, you may find this behavior immoral, but it is not criminal, end quote, lawyer Tenny Garagos said, bashing the victims as gold diggers. I wonder if that's Mark Garagos. I wonder if he's in relation to Mark Garagos. Probably his son. The siblings have pleaded not guilty. Prosecutors, their lawyers, seem to sniff are prudes. Prosecutors, their lawyers seem to sniff are prudes. Okay, that doesn't make sense. Okay. However, their dozens of alleged victims, some dating to their high school days, aren't as quote unquote fun-loving as the poor, misunderstood Alexander brothers. In a nod to the U.S. justice system, the Toff trio have been locked up since December 2024. Besides their parents, Alon Alexander's model wife, Shani Zigron, has been a frequent flyer in the courtroom. According to the Daily Mail, like a lovesick teenager, she had blocked out the final days of February in her Barbie pink diary. Alon coming home now. While the Alexander brothers' image was hammered in the run-up to the expected month-long trial, the courthouse floors have been bloodied by one lurid allegation after another. Watching as the video showed FBI agents raiding her Miami mansion and rummaging through her closet, Zigron wiped away a steady flow of tears. Her husband smiled at her, but the situation got much worse. FBI Special Agent Kristen Chandler testified that she recovered three memory cards from, that says cords, but I think it's cards, from a drawer inside the closet. What investigators found on the cards has not yet been disclosed publicly. The raven-haired Mall shock at the most damaging email among the brothers and their friends discussing an upcoming trip with their wives. Quote, yeah, let's get these girls real wasted. Maybe we'll be able to bang them easier, end quote. One of their friends allegedly wrote, adding that they, quote unquote, used to do it by mixing tequila and Xanax. Quote, I drugged bitches. A video also showed the brothers joking about drugging women on vacation. Zigron laughed as Orrin said on the video, quote, I'm serious, I drug bitches, end quote. Indeed. The former model and Miami society fixture mouthed, quote unquote, I love you to her accused rapist husband. All three brothers have pleaded not guilty to all counts. They are facing life in prison if convicted of the worst charges. In a lot of ways, despite their financial pedigree, staggering self-belief, and arrogance, the brothers, their wives, and family are more like caricatures of the wannabe wealthy. Self-help tapes and success magazines magazine tucked under their arms. Indeed, in 2024, the Miami Herald reported that more than anything, image was the most important thing to the sex-crazed siblings, more so than sex. Quote, start to think about the reputation you want out there, end quote. Oren allegedly said to his older brother Tal, in an email. Quote, we are on top of the game, and the only thing that can bring us down is some hoe complaining, end quote. Tal replies, quote, understood, did someone complain? End quote. Wankers, ultra wankers. And as the horrid crimes allegedly committed by her husband and his brothers were detailed, Oren's wife, Zigron, laughed and smiled. What a pig. Laughed at women being drugged and raped. Nice. And I believe that's the one that he wanted to get out of jail for that baby, delivering of their baby. What a pig. That just goes to show how manipulating they are if their wives believe that they're totally innocent with all the evidence and shit coming out. I mean, it's insane. But she deserves a husband like that if that's how she feels. If she's going to laugh at these victims testifying, I mean, what a pig. Then she deserves a husband like that as far as I'm concerned. Right? I mean, it's like, I just can't. I don't know who she is. I've never heard of her, but I'd like to see her. She seems like a real winner. Now I have some court documents that, what is that? That I want to go over. They think this trial is going to last about a month. It's been 3 weeks. I think this is week 4. So it looks like it might be going on for a little bit longer because they haven't even gotten to the defense's case yet. So, and I'm sure they're going to try and put on all kinds of shit to make them look good. But I think they're going to have a big job on their hands, and they're not going to be able to do much to save their clients. I think their clients are going down. Okay. How come? That's let's see. See if I can make this bigger because I'm blind. I don't think I can. Let's see. That's not going to work. It doesn't have a zoom. Okay, here we go. It's gonna open. Open in reading mode. Okay. But it doesn't open in reading mode. That's weird. Okay, here. Let's... Ooh, that's bad. Want that closed. Open with... There. Okay, here we go. Then share screen. Yes. I knew I'd figure it out. Haha. Okay. United States District Court, let's get rid of that. Southern District of New York. Jane Doe v. Tal Alexander and Alon Alexander. Opinion and order. Jeanette A. Vargas, United States District Judge. Plaintiff Jane Doe filed this suit against Tal and Alon Alexander under New York's violation of the Victims of Gender-Motivated Violence Protection Law. At issue is whether plaintiff can litigate this action under a pseudonym. For the reasons stated below, the motion to proceed under a pseudonym is denied. Wow. That's pretty cold-blooded. So they're going to make her put her name out there. As aligned in the complaint in the summer of 2011, plaintiff accepted an invitation to meet with Alon and his brother Orrin Alexander at their shared apartment. While socializing with them in the living room, she consumed 2 alcoholic drinks containing what she now believes to be the date incapacitating drug that diminished her faculties. Alon Alexander then proceeded to vaginally grape her. Proceeded to vaginally grape the plaintiff in one of the bedrooms. Following this assault, defendant Tal Alexander entered the bedroom and also raped her. Defendants were indicted in December of 2024 on federal sex trafficking charges. The indictment states that, quote, from at least in or about 2010 up to and including at least in or about 2021, the Alexander brothers and with others to engage in sex trafficking, including by repeatedly drugging, sexually assaulting, and raping dozens of female victims. The criminal case is, as well as a number of civil suits that have been brought against the defendants and Orrin Alexander, have generated a great deal of media attention. Can you shut the fuck up? Jesus Christ. Sorry about that. On February 27, 2025, plaintiff filed a motion to proceed anonymously pursuant to the federal statute. Plaintiff's counsel filed a declaration in support of the motion, affirming that plaintiff's identity had been disclosed to counsel for Tal Alexander and that plaintiff was prepared to provide a similar disclosure to Alon Alexander once he had retained counsel. No medical or mental health records or any other evidence were submitted in support of the plaintiff's motion. Legal standard. Under Rule 10A of the Federal Rules of Civil Procedure, quote, a complaint must name all the parties, end quote. This requirement, quote, serves the vital purpose of facilitating public scrutiny of judicial proceedings and therefore cannot be set aside lightly. So that's why they can't let her use a pseudonym, apparently. A district court has discretion to grant an exception to the general requirement of disclosure of the names of parties to allow party to proceed under a pseudonym. So it's up to the discretion of the court, apparently. The Second Circuit sets forth a quote-unquote non-exhaustive list of 10 factors that a district court should consider when ruling on a motion to proceed anonymously. Under sealed plaintiff, the factors are 1. Whether the litigation involves matters that are highly sensitive and of a personal nature. 2. Whether identification poses a risk of retaliatory physical or mental harm on the party seeking to proceed anonymously, or even more critically, to innocent non-parties. And I would say that there is a risk of retaliatory behavior because they've already been caught trying to intimidate witnesses once before. So I don't know why that is not being taken into consideration. And they don't even know how the lady in Australia died yet either, so there's that. 3. Whether identification presents other harms and the likely severity of those harms, including whether the injury litigated against would be incurred as a result of the disclosure of the plaintiff's identity. 4. Whether the plaintiff is particularly vulnerable to the possible harms of disclosure, particularly in light of his or her age. Okay, sorry, I have cotton mouth really bad. You'd think I smoked a doobie or something. Whether the suit is challenging the actions of the government or that of private parties. Number 6. Whether the defendant is prejudiced by allowing the plaintiff to press his or her claims anonymously. Whether the nature of that prejudice, if any, differs at any particular stage of the litigation, and whether any prejudice can be mitigated by the district court. 7. Whether the plaintiff's identity has thus far been kept confidential. And 8. Whether the public's interest in the litigation is furthered by requiring the plaintiffs to disclose his or her identity. 9. Whether, because of the purely legal nature of the issues presented or otherwise, there is an atypically weak public interest in knowing the litigants' identities. And number 10, whether there are any alternative mechanisms for protecting the confidentiality of the plaintiff. A district court is not required to list each of the factors or use any particular formulation as long as it is clear that the court balanced the interests at stake in reaching its conclusion. Rule. And in order to receive the protections of anonymity, I can't say that word, a party must make a case rebutting that presumption. Discussion. Roman numeral 1. Matters of a highly sensitive and personal nature. Under the first sealed plaintiff factor, the court analyzes whether the litigation involves matters of a sensitive and personal nature. Plaintiff contends that the traumatizing nature of her SA allegations easily meets this test. The court agrees that allegations of SA are paradigmatic examples of highly sensitive and personal claims. The court also concurs with plaintiff that this factor weighs particularly heavily in this case due to the notoriety of the defendants. Plaintiff has a substantial privacy interest in protecting herself from the public scrutiny she will endure if her identity is revealed as an alleged victim of these defendants. But although this factor weighs in plaintiff's favor, it is not dispositive. Doe v. Skyline Automobiles. Oh, they're quoting that case. Okay. As Judge Lehman recently explained in Doe 1 v. Branca, USA, quote, a claim by an adult plaintiff to have been the victim of SA and to have suffered physical or psychological damage as a result, accompanied by sufficient facts to support that claim, is not enough to entitle a plaintiff to proceed anonymously. Were it otherwise, virtually all claims of adult sexual assaults would ipso facto proceed anonymously. Accordingly, courts in this district have denied similar motions to proceed anonymously in SA cases, including in cases involving public figures such as Kevin Spacey, Harvey Weinstein, and Sean Combs. The threat of significant media attention, however, exacerbated by the modern era, alone does not entitle a plaintiff to the exceptional remedy of anonymity. Roman numeral 2. Risk of physical retaliation or mental harm and likelihood and severity of the harm. The second and third sealed plaintiff factors address the harm that would occur from the disclosure of the plaintiff's identity. The relevant inquiry is, quote, whether disclosure of the plaintiff's name in the course of the lawsuit would uniquely cause harm and how grave the resultant harm would prove to be, end quote. Well, there's no way to know that until it happens. Okay, a plaintiff must establish with sufficient specificity the incremental injury that would result from disclosure of her identity, end quote. Plaintiff does not provide any evidence that she will be or has been subjected to any sort of threats or intimidation if her identity were to become known. Although plaintiff argues that the, quote, likelihood of further psychological injury overcomes any presumption of openness, end quote, plaintiff offers no specific evidence from a medical expert predicting the revelation of the plaintiff's identity would likely cause psychological and emotional pain so intense that it would threaten her stability, her safety, and even her life. Without such corroborating evidence, this court cannot, quote, speculate about the nature and severity of any mental injury from disclosure, end quote. Ultimately, this factor cuts against plaintiff's request to proceed anonymously. Roman numeral 3. The fourth sealed plaintiff factor requires courts to determine whether the plaintiff is particularly vulnerable to the possible harm of disclosure, particularly in light of her age. A plaintiff's age is a significant data point because, quote, courts have been Courts have been readier to protect the privacy interests of minors in legal proceedings than of adults, end quote. Plaintiff is an adult and does not indicate whether she was a minor at the time of the alleged assault or what aspect of her age makes her vulnerable to the potential harms of disclosure. This factor does not support plaintiff's request to proceed anonymously. Roman numeral 4. Government action or private action. The court must also consider whether the suit challenges the actions of the government or that of private parties. When a lawsuit challenges governmental actions, actors, or policies, the plaintiff has a strong interest in proceeding anonymously. Defendants here are private individuals, and therefore this factor weighs against plaintiff's request to proceed anonymously. Roman numeral 5. Scope, extent, and possible mitigation of prejudice to defendant. Also relevant to this analysis is the prejudice a defendant may face. Specifically, courts have examined difficulties in conducting discovery, the reputational damage for defendants, and the fundamental fairness of proceeding anonymously. Plaintiff asserts that defendants would not be prejudiced by an anonymous proceeding because defendants know specifically who filed the lawsuit. Although defendants know who plaintiff is, concealment of plaintiff's identity from the public can still hamper defendants' ability to conduct discovery. For example, persons with information about plaintiff or her allegations that would be helpful to the defense but were unknown to the defendant might not come forward. This is especially true in a case like this that happened over a period of 10 years, where evidence and witnesses may be difficult to find. Additionally, by bringing this action, plaintiff has put her credibility in issue. How is coming forward for being SA'd put your credibility in issue? That's victim blaming, basically. Defendants are therefore entitled to investigate her background and challenge her allegations and her credibility. This asymmetry between the parties not only would prejudice defendants but would hinder the judicial interest in accurate fact-finding and fair adjudication. Recognizing the prejudice against a defendant when a defendant is required to defend itself, it should be himself, publicly before a jury, while plaintiff could make her accusations from behind a cloak of anonymity. This one-sidedness creates a prejudicial imbalance against defendants. As in Freyden, these accusations are serious and reputation threatening and have already garnered significant media attention. Therefore, this factor cuts against plaintiff's motion. Roman numeral 6. Status of confidentiality in the proceedings. The seventh sealed plaintiff factor is whether plaintiff's identity has been kept confidential. Plaintiff claims that other than filing of her civil claims and the disclosures of her identity to defendants, she has kept the details of the case and her identity confidential. Plaintiff also states that she has not publicly spoken to the media about her experiences with defendants, despite the ample opportunity with the news frenzy surrounding defendants' recent arrests. Assuming arguendo that plaintiff's representation is accurate, this factor weighs in her favor, even though defendants know who she is. While this factor weighs in plaintiff's favor, however, the seventh factor is not significant enough to tip the scales. Roman numeral 7. Public interest in litigation furthered by disclosure. The court also finds that the public interest would be furthered by requiring plaintiff to disclose her identity. Courts have put weight on the right of the public to know the identity of the litigants, as well as on the interest of the accused to be able to publicly confront their accuser. Therefore, something more is required to rebut the presumption of public access, at least in cases involving adult SA, and that something more frequently has to be evidence of real and not conclusory. harm that is substantial and that will flow directly from and is directly linked to disclosure of the party's name. Plaintiff alleges that there are still more victims of the defendants who have not yet spoken out. And if this court grants her anonymity, then more women will feel that they are able to come forward. The court agrees that there is a public interest in protecting SA victims so that other victims will not be discouraged from pursuing legal actions, but it does not follow that the public has an interest in maintaining the anonymity of every person who alleges SA or other misconduct of a highly personal nature. I would say SA is more than personal. It's illegal, for one. Otherwise, this factor would, in fact, heavily favor anonymity in every SA case. The generalized interest in encouraging SA victims to come forward has been repeatedly rejected by courts in this district as an adequate basis by itself to warrant anonymity. It also must be recognized that there is a public interest in being able to publicly confront an accuser. In that same vein, the public has a significant interest in open judicial proceedings, and the public's interest in the litigation is furthered by transparency, including exposure of the parties' identities. Taking the competing interests as a whole, they cut against plaintiff's request for anonymity. Roman numeral 8, nature of the issues. The ninth sealed plaintiff factor is whether, because of the purely legal nature of the issues presented, there's an atypically weak public interest in knowing the litigants' identities. Here, there are no abstract questions of law at issue, such as abstract challenges to public policies, but rather particular actions and incidents. Additionally, cause-raising claims of SA are the type that further the public's interest in enforcing legal and social norms. As the court explained in that case, any analysis and litigation in this case will be factual in nature, and the public interest in SA is very high. Therefore, this factor weighs against allowing the plaintiff to proceed anonymously. That's pretty sad that the public interest in SA cases is so high. What does that say about us, about the public? Roman numeral 9. Alternative mechanisms for protecting confidentiality. The court finds that there are alternative mechanisms that can protect plaintiff's interest in confidentiality. Like the alternative mechanisms proposed in Weinstein, plaintiff could, that's Harvey Weinstein, right? Plaintiff could seek to either redact certain sensitive information or seek a protective order. Accordingly, this factor weighs against plaintiff's request to proceed anonymously. So are they saying that if she insists on being anonymous, they're not going to bring these charges against these guys? Because they still broke the law, whether she's anonymous or not. Conclusion: plaintiff's allegations are not to be taken lightly, and her desire to proceed anonymously is understandable and not to be trivialized. The court, however, must apply the law to the facts. At bottom, plaintiff has not effectively rebutted the presumption of public access. The majority of the sealed plaintiff factors do not weigh in plaintiff's favor, and she has not sufficiently demonstrated that her interest in anonymity outweighs the prejudice to defendants and the customary and unconstitutionally embedded presumption of openness in judicial proceedings. Accordingly, plaintiff's motion to proceed anonymously is denied. Given the sensitivity of the allegations in this case, the court stays the effect of this order for 7 days to allow plaintiff and her counsel to consider this ruling. Wow. That's kind of shitty, if you ask me. That's why more SA victims don't come forward, if you ask me. Because they can't stay anonymous. I mean, that's kind of bullshit. Especially with these rich guys, these assholes, they can find her, so, you know what I mean? They can get to her. And they will do anything to not go to prison. And what that might include is, I mean, we can't really speculate on it, but I think most of us can figure it out. Is this one I just read? Okay, this is a okay, this is a complaint for damages by another Jane Doe, and they are demanding a jury trial. Let me see. What is this? To the above named defendant, you are hereby summoned to answer the complaint in this action and to serve a copy of your answer, or if the complaint is not served with the summons, to serve a notice of acceptance on the plaintiff's attorneys within 20 days after the service of the summons, exclusive of the day of service, where service is made by delivery upon you personally within the state or within 30 days after completion of service, where service is made in any other manner. In case of your failure to appear or answer, judgment will be taken against you by default for the relief demanded in the complaint. So basically, if they don't show up for this, they will be, everything that she's asking for, it will be granted, apparently. Okay, so let's go through this. This was filed on 2/25/25. Okay. Okay, plaintiff Jane Doe brings this action against Alon Alexander, Oren Alexander, and Tal Alexander, collectively defendants, or the Alexander brothers, to recover damages arising from the injuries she suffered because of defendants' sexual abuse, and alleges as follows. Um, For over a decade, the Alexander brothers raped and tormented women with impunity. From the gleaming penthouses of New York and Miami, using their wealth, social connections, and carefully crafted public personas, they engaged in and meticulously concealed a sweeping enterprise of sexual violence. Plaintiff is a survivor of that violence. With this action, she seeks to hold the Alexander brothers accountable for what they did to her and for their devastating campaign of abuse against dozens of women. 2. Behind the facade of their successful real estate business, defendants executed a calculated pattern of predation. They weaponized their social media presence, exploited their connections to celebrities and influencers, and deployed their wealth to create elaborate traps for young women. Their methodology was precise: identify vulnerable targets through social media, orchestrate seemingly innocent meetings, I lost my place now. Oh my God. Innocent meetings, isolate and prey on women in their luxury apartments, employ intoxicants to facilitate their assaults, and then manipulate and scare their victims into silence. 3. The scale of defendants' operation is staggering. In announcing federal criminal charges against defendants on December 11, 2024, U.S. Attorney Damian Williams revealed the horrifying scope. Quote, as alleged in the indictment, for more than a decade, the Alexander brothers alone and together repeatedly and violently essayed and raped dozens of female victims. Today, the defendants are charged with multiple sex trafficking offenses, period. Our investigation is far from over, end quote. U.S. Attorney Williams asked more women to come forward, continuing, if you have been a victim of the alleged sexual violence perpetrated by these defendants, or if you know anything about their alleged crimes, we urge you to come forward. Number 4. The criminal charges have empowered dozens of women, including plaintiff, to break their silence. Like many others, plaintiff was strategically targeted and brutally assaulted in the defendant's New York penthouse. Her experience bears the hallmarks of their established pattern. Footnote 1. Press release, U.S. Attorney's Office, Southern District of New York, Alon Alexander, Orrin Alexander, and Tal Alexander, charged in Manhattan federal court with sex trafficking offenses. The use of social media to identify targets, the deployment of drugs to incapacitate victims, and the coordinated participation of multiple brothers in the assault. 5. Accordingly, plaintiff brings this action to hold defendants accountable for their violations of the victim's gender, or violations of the victims of gender motivated violence protection law. Their systematic gender-motivated violence reflects not merely opportunistic criminality, but a deliberate enterprise built on the targeted exploitation and abuse of women. Number 6, plaintiff Jane Doe is a resident of New York State. Given the sensitive nature of this action and the SA allegations contained herein, plaintiff proceeds under a pseudonym to protect her privacy and will file the appropriate motion. Okay, well, didn't they just say? I wonder if it's the same Jane Doe then, and they said she can use a pseudonym, or if it's a different one. Number 7, defendant Tal Alexander resides in Brooklyn, New York, specifically the Metropolitan Detention Center in Brooklyn, New York. Indeed, upon information and belief, prior to the incarceration, Tal lived in New York. Number 8, defendant Alon Alexander resides in Brooklyn, New York, specifically the MDC in Brooklyn. Number 9, defendant Orrin Alexander resides in Brooklyn, New York, specifically the MDC. Roman numeral 3, jurisdiction and venue. Number 10, the court has personal jurisdiction pursuant to civil practice law and rules. Inter alia, because plaintiff and defendants reside in New York and the horrific assaults occurred in New York. 11, venue is proper in this county pursuant to, then it gives the code, the statute, because a substantial part of the events giving rise to plaintiff's claims took place in New York County. Okay. Roman numeral 5. Factual allegations. A Jane Doe was systematically targeted and suffered a devastating SA by Alon, Tal, and Orrin Alexander. 12. In 2016, when plaintiff was 20 years old, she responded to an Instagram story by Chantel Jeffries, a prominent celebrity disc jockey with millions of followers, seeking someone to go on a date in New York City. Number 13, plaintiff's friend also responded to an Instagram story by Chantel Jeffries on behalf of plaintiff. Number 14, plaintiff's friend ultimately connected with Alon via Instagram. 15, plaintiff's friend told Alon that she wanted to set up plaintiff with a loyal and family-oriented man for a long-term relationship. The below depicts the conversation between Alon and plaintiff's friend. These must be their text messages. Executing his practiced predatory pattern, Alon messaged plaintiff from information supplied by her friend in what would later prove to be a calculated scheme. He struck up a conversation with plaintiff on Instagram before transitioning their communications to text messages, giving plaintiff a false sense of trust. Her friend probably feels like shit for getting her in this situation. Number 17, he strategically invited her to meet him for dinner in Manhattan. Trusting his representations, plaintiff drove to Manhattan to meet Alon at the specified location. 18, upon arrival, plaintiff discovered there was no restaurant at that location. Creepy. The first of many intentional deceptions. Alon said he was at a bar and invited her to join. Plaintiff told him that she was 20 years old and could not go to a bar. Alon then smoothly redirected plaintiff to his apartment located in New York City, New York, under the pretense that they would proceed to dinner afterward. What a pig. Number 19, plaintiff arrived at Alon's penthouse apartment building in New York City, where the building security required plaintiff's identification and signature before permitting her entry to defendant's penthouse apartment. Security kept her identification as she went upstairs. 20, Once inside the apartment, Alon immediately presented plaintiff with a pre-prepared drink, a signature element of the defendant's methodical assault pattern. After consuming only a portion of the drink, the plaintiff began experiencing severe and unusual disorientation, for beyond the effects of normal alcohol consumption. 21. Alon then told plaintiff that he would show her around the defendant's apartment. During the tour, Alon brought plaintiff to a bedroom where his brother Tal was in bed with a woman watching television. Ew. Yuck. Ew. 22. Plaintiff went to introduce herself to Tal with a kiss on the cheek. She walked up to him while he was in bed with a girl and gave him a kiss on the cheek. Okay. As she did so, Tal turned his head and forcibly kissed her on the lips. 23. Plaintiff and Alon left Tal and the woman, ultimately coming to rest on a sofa in a bedroom within the apartment. On the sofa, Alon began to kiss and touch the plaintiff. 24. Plaintiff physically resisted Alon's advance, removing his hands from her body. 25. She also told Alon to stop, making clear that she did not want to engage in sexual activity with Alon. 26. Plaintiff does not remember how she got on the bed, but remembers feeling a sense of hopelessness once she was there. 27. On the bed, Alon told plaintiff that if he could not touch her, she would have to perform oral sex on him. This is bothersome, going through this step by step. Despite plaintiff's explicit verbal refusals and physical resistance, Alon grabbed the plaintiff's head to force her to his penis. He physically controlled her head and forced her to perform oral sex on him. Trigger warning, if this is going to be too much for you, you might want to leave or stop watching now, because I have a feeling it's going to get pretty detailed from the way it's going so far. 29. While the plaintiff was being forced to perform oral sex on Alon, a third brother, Orrin Alexander, approached the plaintiff from behind and began removing her clothes without her consent. 30. Orrin then raped the plaintiff from behind while she was being forced to continue performing oral sex on Alon. 31. Alon and Orrin then switched positions and continued to grape her. 32. Throughout the horrific assault, plaintiff was in an impaired and disoriented state, likely due to an intoxicant in the drink provided by Alon. She experienced freezing dissociation and felt helpless to resist or escape during the assault. 33. Defendant Tal's presence in the apartment was no coincidence, but rather part of the defendant's coordinated scheme. During the apartment quote-unquote tour, Alon deliberately brought plaintiff to Tal's bedroom, where Tal was positioned with another woman to normalize the presence of multiple men and create an environment of implied sexual activity. 34. Tal's forcible kiss of plaintiff during his turning his head to convert her greeting into an unwanted sexual contact marked the beginning of the defendant's orchestrated assault. This initial violation served to test plaintiff's boundaries and gauge her capacity to resist. 35. Throughout plaintiff's assault by Alon and Orrin, Tal remained in the apartment within earshot of the ongoing attack. Tal's presence in the apartment served multiple roles in defendant's scheme. It helped establish a false sense of safety through the appearance of a double date scenario, provided additional pressure against plaintiff's resistance, and ensured that she could not escape or seek help from others in the apartment. Tal took no action to intervene or assist her. His participation extended beyond mere presence to active facilitation of the assault scheme through his actions and strategic inactions. 36. After sexually violating the plaintiff, defendants Alon and Oren left her alone in the room, treating the violent assault as if it were insignificant. 37. Plaintiff, in a state of shock and confusion, gathered her clothes and fled the apartment. She got her identification back from the security desk before she left. 38. This pattern of coordinated activity among the defendants, with each playing specific roles in facilitating horrific sexually violent assaults, is consistent with the defendants' criminal indictments, allegations of their joint enterprise of sexual violence, using luxury properties as staging grounds, maintaining the presence of multiple brothers to overwhelm the victims, and leveraging each other's presence to create an environment of implied consent and intimidation. 39. The sexual assault was substantially motivated by defendants' animus toward women, as evidenced by defendants. A sophisticated and coordinated efforts to lure plaintiff to the apartment under false pretenses, including the calculated use of a female celebrity's social media platform to create a false sense of security. B. Premeditated use of alcohol. C. Alcohol or other intoxicants to impair and incorporate to impair and incapacitate plaintiff, as demonstrated by the pre-prepared drink waiting upon her arrival. C. Complete disregard for plaintiff's explicit verbal refusals and physical resistance, showing their view that women's expressions of non-consent are meaningless. They finally probably find it somewhat challenging, as a challenge, see if they can overcome the women's resistance. D. Coordinated use of physical force and coercion, including forcibly controlling plaintiff's head and body movements while she was in an impaired state. E. Treatment of plaintiff as a mere object for their sexual gratification rather than a human being, demonstrated by their coordinated passing of her between them without any regard to her autonomy or dignity. F. Cavalier attitude after the assault, demonstrating their view that violating women is inconsequential. Well, I think that goes without being said. That's why the fact that his wife laughed at the victims in the courtroom is disgusting. And she's just as bad as they are, as far as I'm concerned. If she's that stupid and she doesn't believe this stuff's happening, I don't believe that for a minute. I think she knows, and she just doesn't give a shit. As long as she gets what she wants out of him and his money, then to hell with the rest of it. Strategic division of roles during the assault, with each defendant performing specific actions as part of their coordinated attack. H. Exploitation of their wealth, status, and social connections to create an environment where they believed themselves immune from consequences. And I. Pattern of targeting young, vulnerable women through social media and mutual connections, showing their deliberate selection of victims they believed they could overpower and silence. 40. As a direct and proximate result of defendant's actions, plaintiff has suffered severe and ongoing emotional distress, psychological impairment, and economic damages, including but not limited to intrusive memories and flashbacks of the horrific assault, severe anxiety in social situations, difficulty maintaining intimate relationships, sleep disturbances and nightmares, hypervigilance, and an exaggerated startle response, as well as panic attacks triggered by environmental stimuli reminiscent of the assault, and will have an ongoing need for psychological treatment and therapy. 40, whoops, where am I? Where'd 41 go? It skips to 44. Why does it skip to 44? Okay. B. The Alexander brothers had a well-known penchant for sexually assaulting women. 41. Unfortunately, plaintiff is far from the only victim of the Alexander brothers. 42. For years, defendants engaged in a similar pattern of schemes, acts, and conduct with different women, many of whom have found the courage to come forward and seek justice. Number 43. As they quote-unquote build an image as jet-setting bachelors, defendants were quietly earning another reputation. Accusations that they incapacitated and essayed women were spreading throughout the world of high-end real estate. And so it should. Right? Number 44. Two brave women, Rebecca Mandel and Kate Whiteman, stood up in March 2024 and filed suit in New York against Alon and Oren, accusing them of assault, battery, and rape. 3. They alleged a similar pattern of behavior against other women. 45. They were correct. A third woman, Angelica Parker, filed the lawsuit in June of 2024, accused all three brothers of rape. She noted in her complaint that 30 more women came forward after news broke of the initial lawsuits against the defendants. 46. Like the plaintiff, Ms. Parker was a victim of a coordinated SA. She was vaginally raped and forcibly orally raped at the same time by defendants. Upon further investigation, dozens of former classmates, brokerage employees, and agents have said that they had knowledge of incapacitating and violent SA by the brothers, dating back at least 20 years. Oh man, I thought it was only like 10 years. Not that that makes it any better, but holy shit. Dating back at least 20 years to when the men were high school students. Number 48. Law enforcement agencies around the country have followed these brave women and filed criminal charges against the defendants. 49. A federal grand jury in the Southern District of New York indicted Alon, Oren, and Tal in December of 2024. The U.S. Attorney's Office alleged repeated and violent incapacitating, assaulting, and raping of dozens of women since at least in or about 2010. The indictment alleged that defendants used their wealth to lure women to locations where they were forcibly raped, then sometimes by where they were forcibly raped, sometimes by the defendants and sometimes by multiple other men, and often with the aid of incapacitators to prevent the women from fighting back. The allegations demonstrate defendants had a history of incapacitating and assaulting women using a playbook almost identical to what they used on the plaintiff. 51. As outlined in the superseding indictment, Alon, Oren, and Tal used social connections or the guise of starting a relationship to lure and entice women to meet. Then essayed the women, sometimes within hours of their meeting. Well, with the plaintiff, it sounds like it was within minutes of their meeting. Number 52, defendants used deception, fraud, and coercion to get women to meet them in private locations. They then used various methods, including incapacitating the victims and at times physical force, to grape and essay the victims. Sometimes alone and sometimes together. Number 53. Federal prosecutors say that they've spoken to more than 60 alleged victims of the 3 men so far and have videos of defendants engaged in sexual acts with who appear to be under the influence of incapacitators or alcohol. They plan to bring more charges. They plan to bring more charges, period. 54. State authorities have filed charges too. Oren and Alon face felony sexual battery charges in Miami-Dade for 3 incidents involving 3 different women. 55. According to one of the victims, she took a drink from Oren, began to feel weird, and did not have the strength to push Oren away as he graped her. 56. Another victim described a harrowing scene. As she was forcibly pinned down, Alon and Oren asked each other, "Do you want to go first? Do you want to go first?" before graping her. Wow. This is insane. Roman numeral 5. Plaintiff's claims first cause of action. Violation of the Victims of Gender-Motivated Violence Protection Law. Plaintiff repeats and realleges each and every allegation contained in the preceding paragraphs as if fully set forth herein. 58. This claim is brought against defendants Alon, Oren, and Tal. 59. As set forth below, defendants violated the Victims of Gender-Motivated Violence Protection Law by, quote-unquote, committing a crime of violence motivated by gender. Number 60. The VGM-VPL defines a crime of violence motivated by gender as a crime of violence committed because of gender or on the basis of gender and due, at least in part, to an animus based on the victim's gender. Put together, the elements of the violation of the VGM-VPA are: 1. The alleged act... Where am I? Okay. The alleged act constituted a misdemeanor or felony against the plaintiff. 2. Presenting a serious risk of physical injury. 3. That was perpetrated because of plaintiff's gender. And 4. In part because of animus against plaintiff's gender. Number 62. Defendants' actions meet the first element of a VGM-VPL violation, as their misconduct violates Article 130 of the New York Penal Law. Alon Oren violated Section 130.35, rape in the first degree, for vaginal sexual contact. Conduct constituting a felony. The drink left plaintiff disoriented and unable to physically resist defendant's SA. D. Wait a minute, I skipped some. Okay, A. Allen and Oren violated Section 130.35, rape in the first degree, by forcible compulsion and oral sexual contact. By forcible compulsion. Not only was the rape by forcible compulsion, but plaintiff was also incapable of consent by reason of being physically helpless, given the drink Alon gave her. B. From the same facts, Alon and Oren also violated lesser related offenses, including Section 130.65, sexual abuse in the first degree. C. Alon also violated Section 130.90, facilitating a sex offense with a controlled substance, by giving plaintiff a pre-made drink without her consent and with intent to commit conduct constituting a felony. The drink left plaintiff disoriented and unable to physically resist defendant's sexual assault. D. Tal is criminally liable for his brother's violations of Article 30 because under Section 20.000, he intentionally aided their SA of plaintiff with full knowledge of their plans to violate her. 63. Defendant's actions presented a serious risk of physical injury. As stated above, the direct and proximate result of defendant's gender-motivated violence is that plaintiff has suffered and continues to suffer severe and ongoing emotional distress, psychological impairment, and economic damages, including but not limited to intrusive memories and flashbacks of the assault, severe anxiety in social situations, difficulty maintaining intimate relationships, sleep disturbances and nightmares, hypervigilance, and an exaggerated startle response, as well as panic attacks triggered by environmental stimuli reminiscent of the assault, and will have an ongoing need for therapy. 64. Defendant's violent acts were motivated by gender, as evidenced by defendants as outlined herein. Number 65. Additionally, the Appellate Division First Department has held that where the plaintiff is an alleged victim of rape, an allegation of rape is sufficient to show animus on the basis of gender. Then it gives case law. 66. Plaintiff brings this action under VGM VPL's revival statute passed by the New York City Council in January 2022, which allows otherwise time-barred claims to be brought until March 1st, 2025. Could you imagine the city council meetings that they must have in New York? Probably fucking huge compared to like a normal city council meeting. 67. Plaintiff seeks compensatory damages, punitive damages, attorney's fees, costs, and such other relief as the court deems just and proper under the statute. Number 68. The defendant's misconduct was willful, wanton, malicious, and oppressive, and manifested a conscious disregard for plaintiff's rights and safety, thereby warranting punitive damages under the common law standard for the purpose of punishing and deterring reprehensible conduct. Meaning, if we make you pay a shit ton of money, you'll be less likely to fuck up like this again. But unfortunately, I don't think that shit works for these guys, because these guys are just fucking pigs. Just 1 second. Okay. Okay, so where are we? Prayer for relief, wherefore the plaintiff demands judgment against defendants for the above referenced claims and causes of action, and as follows. 1. Award compensatory damages in an amount to be determined at trial, including but not limited to damages for A. medical expenses, past and future, B. impaired earning capacity, C. past and future emotional distress and psychological trauma, D. past and future loss of enjoyment of life. How can you put a price on that? That's crazy. 2. Award punitive damages in an amount to be determined at trial sufficient to punish defendants for their willful and malicious conduct and to deter similar conduct by others. 3. Award prejudgment and post-judgment interest to the fullest extent permitted by law. 4. Award reasonable attorney's fees and costs. 5. For such other and further relief as the court may deem just and proper. Demand for a jury trial. Plaintiff hereby demands a trial by jury on all claims so triable. And there you have it. Sad. Very sad. So, as I've been telling you, I'm following this trial every day, looking for updates from people that are actually going and watching the proceedings in the courtroom. And as I get updates on what is happening as far as witness testimony, victim testimony, evidence, and everything else, I will continue to keep you apprised of these proceedings also. So just keep checking, and I will keep checking, and I will keep you informed as to what's going on, and hopefully these pigs suffer the fullest extent of the law for what they've done, so that these victims can start to heal. They'll never heal completely, but they can rest assured knowing that these guys are put away, hopefully for life, and they can try and move on with their lives knowing that these guys can't ever touch them again or even get to them again. So on that note, I hope everybody has a good evening, and I will see you soon. Stay warm, stay dry, stay happy, and until next time, bye. Don't forget to like and subscribe.